Hello, hello, good evening, everybody. Good evening, welcome in. Good to see you all. Welcome. I do have the comments turned off just while I read the first couple documents here, and then I will turn them back on for a Q&A here in just a little bit. So welcome in, everybody. Good to see you all, as always. Hello, Lisa. Oh, thank you. Thank you so much. I appreciate that. I think I saw Frank too. Yep, there he is. Hi, Frank. Hope everyone is having a good day and is able to stay out of the super cold weather that's going on out there. Wishing everyone the best. So tonight, everyone, I am planning to jump straight into a couple of different things. We've got lots to catch up on for tonight. So we did have, just as a reminder, we had the Court of Appeals for the DC Circuit arguments today, and I was live, and we were listening to those. I will go over those a little bit towards the end here at the live. We also had our joint discovery status that was filed in the Florida case, so I have printed that out. It's only a couple pages, so I will take you through that for tonight. I also have a few motions and things that were filed in the Georgia case, so I will be reviewing those documents as well. So we'll be doing an update on the Court of Appeals. We'll do a Florida quick update and a Georgia quick update as well. So that's kind of my plan for tonight. I did want to kind of start the evening though, just doing a brief review of two very important cases that I think are helpful in going through that the Court of Appeals arguments that we went through on the immunity issue. So I will start with that. It's only about 2 or 3 pages of a brief that I will read to you from the very beginning introduction of the cases to give you an idea of what's going on, but I think it'll be really helpful for our immunity discussion. So I'll start with that. Then I will go into the joint discovery status, then review the Georgia motions, then I will turn on Q&A so we can talk about all of those things. So here we go. We'll get started with the cases first, everybody. The first case that we will go over here will be, they were both decided the same day. Yikes. Which one should I do? Okay, we'll do this one first. We'll do this one first. So, welcome. Now, if anyone was hanging out with me earlier today, for any of the lives, oh my gosh, how many times have I gone live today? I've forgotten everybody. But we did listen to the oral arguments out of the DC Circuit, and we were talking about presidential immunity. Oh, thank you for the roses, everybody. I appreciate it. We were talking about presidential immunity. Now, I had been making several comments about how the United States Supreme Court has already kind of set the doctrine out when it comes to presidential immunity. There's really not too much to kick around with this particular issue because this precedent's already been set. Now, Mr. Trump's attorney today was asking for a new precedent to be set, which you can do. That's part of our process. But whether or not that will happen out of the Court of Appeals, we don't know. So I thought I would take you through, again, just an introduction and overview of a couple of the key cases when it comes to presidential immunity that have just come out, so you can kind of get a feel for how the judges of this SCOTUS have been feeling about it. Hello, Kristen. Welcome. So the first case will be the Trump versus Vance District Attorney of the County of New York case. Now, I will, again, just a couple pages here, and then I will also review Trump versus Mazars. Oh, there's the kitty. My kitty has a sitter right now, so... And this will be the second case I go through. Now, both of these cases were requested that I do spend some time going on them during a live. So I thought today would be the perfect opportunity because we are dealing with presidential immunity questions today. So the first case here, again, this all came about, if anyone remembers, due to some subpoenas that were being requested, that were issued. And there were subpoenas being sent to Mr. Trump regarding both of these two different cases. They were decided on the same day, but two different issues. We've got a state court who is wanting to subpoena a sitting president at the time. So note the date. So a sitting president in order to obtain records of wrongdoing. And then the second case that I'll go through next in the Mazars case we have Congress as well as a state jurisdiction who is issuing subpoenas. So SCOTUS came out in both of these cases with a couple of decisions explaining the separation of powers question, set out a couple of tests. So I thought I'd take you through that first tonight. So, and then next up, I will go through Florida. So here we go, everyone. I will just read you through, again, this synopsis of this particular case. If you are wondering which case I'm doing, I won't put a sticky note on here, but the name of the case will be at the top of the decision. So here we go. Again, decided July 9th of 2020. In 2019, the New York County District Attorney's Office, acting on behalf of a grand jury, served a subpoena, ducis tecum, which I will say incorrectly every time, everyone, and this is a request for documents as well as witness testimony, on Mazars, the personal accounting firm of President Donald J. Trump, for the financial records relating to the president and his businesses. The president, acting in his personal capacity, sued the district attorney and Mazars in federal district court to enjoin enforcement of the subpoena, arguing that a sitting president enjoys absolute immunity from state criminal process under Article 2 and the Supremacy Clause. The district court dismissed the case under the abstention doctrine of the Harris case, and in the alternative, held that the president was not entitled to injunctive relief. The Second Circuit rejected the district court's dismissal under the Harris-Younger case, but agreed with the court's denial of injunctive relief, concluding that presidential immunity did not bar enforcement of the subpoena and rejecting the argument of the United States as amicus curiae that a state grand jury subpoena seeking the president's documents must satisfy a heightened showing of need. So that's our facts, set it out for this first case. So the court, SCOTUS again here, held Article 2 and the Supremacy Clause do not categorically preclude or require a heightened standard for the issuance of a state criminal subpoena to a sitting president. The timing is very important on this case. Subsection A. In 1807, John Marshall, presiding as a circuit justice for Virginia over the treason trial of Aaron Burr, granted Burr's motion for a subpoena, ducis tecum, directed at President Jefferson. In rejecting the prosecution's argument that a president was not subject to such a subpoena, Marshall held that a president does not stand exempt from the Sixth Amendment's guarantee that the accused have compulsory process for obtaining witnesses for their defense. And then they are citing U.S. versus the Burr case. Now, if anyone is interested in me going through that case at some point, please do let me know. I have pulled that case. It's very interesting how they set the cases out back then. The sole argument for an exemption was that a president's duties as chief magistrate demand his whole time for national objects. But in Marshall's assessment, those duties were not unremitting, and any conflict could be addressed by the court upon return of the subpoena. Marshall also concluded that the Sixth Amendment's guarantee extended to the production of papers. The propriety of introducing any papers, he explained, would depend on the character of that paper, not the character of the person who holds it, and would have due consideration upon the return of the subpoena. Jefferson agreed to furnish whatever justice required, subject to the prerogative to decide whether particular executive communications should be withheld. So I'll take one quick break here. Well, thank you for the star. I appreciate that. In the 2 centuries since Burr, successive presidents from Monroe to Clinton have accepted Marshall's ruling that the chief executive is subject to subpoena and have uniformly agreed to testify when called in criminal proceedings. In 1974, the question whether to compel the disclosure of official communications over the president's objection came to a head when the Watergate special prosecutor secured a subpoena, ducis tecum, directing President Nixon to produce, among other things, tape recordings of Oval Office meetings. This court rejected Nixon's claims of absolute privilege of confidentiality for all presidential communications, recognizing that compulsory process was imperative for both the prosecution and the defense. The court held that the president's generalized assertion of privilege must yield to the demonstrated specific need for evidence in a pending criminal trial. And then we're citing the Nixon case here. By the way, this synopsis is just a peek into the case. The opinion was written by Chief Justice John Roberts. Here we go. So President Nixon then dutifully released the tapes. Subsection B. This history all involved federal criminal proceedings. Here, the president claims that the Supremacy Clause gives a sitting president absolute immunity from state criminal subpoenas because compliance with such subpoenas would categorically impair the performance of his Article 2 functions. The Solicitor General, arguing on behalf of the United States, claims that a state grand jury subpoena for a sitting president's personal records must at the very least meet a heightened standard of need. Now, keep in mind the Solicitor General is representing the President of the United States at the time, and that's the perspective of their argument. Subsection 1, the President's unique duties as head of the executive branch come with protection that safeguard his ability to perform his vital functions. The Constitution also guarantees the entire independence of the general government from any control by their respective states, citing the Farmers and Mechanics case out of Minneapolis. Marshall's ruling in Burr, entrenched by 200 years of practice, and this court's decision in Nixon confirms that federal criminal subpoenas do not rise to the level of constitutionally forbidden impairment of the executive's ability to perform its constitutionally mandated functions, citing Clinton versus Jones. But the president claims that state criminal subpoenas necessarily pose a unique threat of impairment and thus require absolute immunity. His categorical argument focuses on three burdens: diversion, stigma, and harassment. So these are the burdens that Trump is putting out. Number 1, the president contends that complying with state criminal subpoenas would necessarily distract the chief executive from his duties. He grounds that concern on Nixon v. Fitzgerald, which recognized a president's absolute immunity from damages liability predicated on his official acts. But contrary to the president's suggestion, that case did not hold that distraction was sufficient to confer absolute immunity. Indeed, the court expressly rejected immunity based on distraction alone 15 years later in Clinton versus Jones, when President Clinton sought absolute immunity from civil liability for private acts. As the court explained, Fitzgerald's dominant concern was not mere distraction, but the distortion of the executive decision-making process. The prospect that a president may become preoccupied by pending litigation did not ordinarily implicate constitutional concerns. 2 centuries of experience likewise confirm that a properly tailored criminal subpoena will not normally hamper the performance of a president's constitutional duties. The president claims this case is different. He believes that he is under investigation and argues that the toll will necessarily be heavier in that circumstance. But the president is not seeking immunity from the diversion occasioned by the prospect of future criminal liability. He concedes that he may be investigated while in office. His objection is instead limited to additional distraction caused by the subpoena itself. That argument, however, runs up against 200 years of precedent establishing that presidents and their official communications are subject to the judicial process, citing the Burr case, even when the president is under investigation, citing Nixon. Number 2, the president next claims that the stigma of being subpoenaed will undermine his leadership at home and abroad. But even if a tarnished reputation were a cognizable impairment, there is nothing inherently stigmatizing about a president performing the citizen's normal duty of furnishing information relevant to a criminal investigation. And they're citing the Brandsburg case. nor can the risk of association with persons or activities under criminal investigation absolve a president of such an important public duty. The consequences for a president's public standing will likely increase if he is the one under investigation, but the president concedes that such investigations are permitted under Article 2 and that the Supremacy Clause and the receipt of a subpoena would not seem to categorically magnify the harm to the president's reputation. Additionally, in the grand jury context, long-standing secrecy rules aim to prevent the very stigma the president anticipates. Subsection 3. Finally, the president argues that subjecting presidents to state criminal subpoenas will make them easily identifiable targets for harassment, citing Fitzgerald. The court rejected a nearly identical argument in Clinton, concluding that the risk posed by harassing civil litigation was not serious because federal courts have the tools to deter and dismiss vexatious lawsuits. Harassing state criminal subpoenas could, under certain circumstances, threaten the independence of effectiveness of the executive, but here again the law already seeks to protect against such abuse. First, grand juries are prohibited from engaging in arbitrary fishing expeditions or initiating investigations out of malice or an intent to harass, citing U.S. v. R. Enterprises. And federal courts may intervene in state proceedings that are motivated by or conducted in bad faith. Second, because the Supremacy Clause prohibits state judges and prosecutors from interfering with the president's official duties, any effort to manipulate a president's policy decisions or to retaliate against a president for official acts through issuances of a subpoena would be an unconstitutional attempt to influence a superior sovereign exempt from such obstacles, citing the McCullough versus Maryland case. And federal law allows a president to challenge any such allegedly unconstitutional influence in a federal forum. Number 2. A state grand jury subpoena seeking a president's private papers need not satisfy a heightened need standard for 3 reasons. First, although a president cannot be treated as an ordinary individual when executive communications are sought, Burr teaches that with regard to private papers, a president stands in nearly the same situation with any other individual. Second, there has been no showing here that a heightened protection against the state subpoenas is necessary for the executive to fulfill his Article 2 functions. Finally, absent a need to protect the executive, the public interest in fair and effective law enforcement cuts in favor of comprehensive access to evidence. Rejecting a heightened need standard does not leave presidents without recourse. A president may avail himself of the same protections available to every other citizen, including the right to challenge the subpoena on any grounds permitted by state law, which usually include bad faith and undue burden or breadth. When the president invokes such protections, the high respect that is owed to the office of the chief executive should inform the conduct of the entire proceeding, including the timing and scope of discovery, citing Clinton. In addition, a president can raise a subpoena-specific constitutional challenge in either a state or a federal forum. As noted above, he can challenge the subpoena as an attempt to influence the performance of his official duties in violation of the Supremacy Clause, and he can argue that compliance with a particular subpoena would impede his constitutional duties. It has been affirmed and remanded. So again, this was a synopsis of the court opinion delivered by Chief Justice Roberts. We had Justice Ginsburg, Breyer, Sotomayor, and Kagan joining. Kavanaugh filed an opinion concurring with the judgment in which Gorsuch joined, and then Thomas and Alito filed dissenting opinions. So just as a quick note, when it came to Kavanaugh's dissent, again, I usually don't spend much time on dissents, but just to give you an idea of where Kavanaugh's mindset was, this is his dissent in part. He agreed with the holding, but added his own piece, which Justice Gorsuch came on with him. The court today unanimously concludes that a president does not possess absolute immunity from a state criminal subpoena, but also unanimously agrees that this case should be remanded to the district court, where the president may raise constitutional and legal objections to the subpoena as are appropriate. So here, he's saying the principle that applies to the course to a president, and at the same time, in light of Article 2 of the Constitution, this court has repeatedly declared, and the court indicated again today, that a court may not proceed against a president as it would against an ordinary litigant. So Kavanaugh's entire premise here is that we just need to be extra careful with presidents. They have a elevated level, an elevated role, and should be treated special. So that's really where he differs from the majority. And specifically, he states, I would apply the longstanding Nixon demonstrated specific needs standard to this case. So he would have applied a bit of a higher standard for a criminal subpoena in a state court. That's where Kavanaugh disagreed, was on the standard, not whether you could or could not do it. Next, then, we've got the next dissent which came up, which is Justice Thomas here. So I think a very important point to note, again, Justice Thomas, the text of the Constitution explicitly addresses the privileges of some federal officials, but it does not afford the president absolute immunity. So he goes further into that, and he wants to talk about this official versus unofficial acts element that is really brought up quite a bit in the Nixon v. Fitzgerald and Clinton v. Jones case. So that was what was important to Thomas and why he was dissenting here with his opinion. So again, I don't usually spend a lot of time on dissents, but just to give you an idea of where he was as well. So this is his final dissenting opinion for Thomas. I would vacate and remand to allow the district court to determine whether enforcement of the subpoena should be enjoined because the president's duties as chief magistrate demand his whole time for national objects. So with that, he's dissenting. So that's his dissent. And then we have Justice Alito dissenting as well. And I think I'll just go through the first paragraph here and then his final words to give you an idea of where Justice Alito stands on this particular issue. This case is almost certain to be portrayed as a case about the current president and the current political situation, but the case has a much deeper significance. While the discussion will, of course, have a direct effect on President Trump, what the court holds today will also affect all future presidents, which is to say, it will affect the presidency, and that is a matter of great and lasting importance to the nation. So his idea was, I think this may be a political situation, and we don't want to deal with that. We need to acknowledge the importance of the office. So I'll take you to the very end here. So this is, again, Justice Alito's dissent. The subpoena at issue here is unprecedented. Never before has a local prosecutor subpoenaed the records of a sitting president. The court's decision threatens to impair the functioning of the presidency and provides no real protection against the use of the subpoena power by the nation's 2,300 plus local prosecutors. Respect for the structure of government created by the Constitution demands greater protection for an institution that is vital to the nation's safety and well-being. I therefore respectfully dissent. So that is Justice Alito's view on that. So if you know any of the background of our justices, that makes sense. So there you have it. That was the Vance case. So let me take you through real quick again. The Mazars case. This was the second case decided that day, again, regarding presidential privilege. And in this one, they did set out a standard regarding subpoenas. I think, again, it's helpful just to see how the Supreme Court is deciding these kinds of issues. So I will take you through this, and then when I'm finished, I will walk you through an update out of Florida and then an update out of Georgia. So here we go, everybody. Again, this is the Trump versus Mazars case. There's several different names for this particular case, but when I flip the page, it will be at the top so that you know it was decided again July 9th of 2020, the same date as the previous case. So here we go. I'll take a quick break. So we're still talking about subpoenas here, but we're talking about different kinds of subpoenas at this point. So the previous case had to do with a state criminal investigation, and now we're going to get into different questions about separation of powers with Congress. So this was decided July 9th of 2020. In April of 2019, 3 committees of the U.S. House of Representatives issued 4 subpoenas seeking information about the finances of President Donald J. Trump, his children, and affiliated businesses. The House Committee on Financial Services issued a subpoena to a Deutsche Bank seeking any document related to account activity, due diligence, foreign transactions, business statements, debt schedules, statements of net worth, tax returns, and suspicious activity identified by Deutsche Bank. It issued a second subpoena to Capital One for similar information. The Permanent Select Committee on Intelligence issued a subpoena for Deutsche Bank that mirrored the subpoena issued by the Financial Services Committee, and the House Committee on Oversight and Reform issued a subpoena to the president's personal accounting firm, Mazars, demanding information related to the president and several affiliated businesses. Although each of the committees sought overlapping sets of financial documents, each supplied different justifications for the request, explaining that the information would help guide legislative reform in areas ranging from money laundering and terrorism to foreign involvement in U.S. elections. Petitioners, the president, in his personal capacity, along with his children and affiliated businesses, contested the subpoena issued by the Oversight Committee in the District Court for the District of Columbia and the subpoena issued by the Financial Services and Intelligence Committees in the Southern District of New York. In both cases, petitioners contended that the subpoena lacked a legitimate legislative purpose and violated the separation of powers. The president did not, however, argue that any of the requested records were protected by executive privilege. In Mazars, the district court granted judgment. So this is the procedural history of this case before it's in front of SCOTUS. So I'll just walk you through that. In Mazars, the district court granted judgment for the House, and the D.C. Circuit affirmed, finding that the subpoena issued by the Oversight Committee served a valid legislative purpose because the requested information was relevant to reforming financial disclosure requirements for presidents and presidential candidates. In the Deutsche Bank case, the district court denied a preliminary injunction, and the Second Circuit affirmed in substantial part, holding that the Intelligence Committee properly issued its subpoena to Deutsche Bank as part of an investigation into alleged foreign influence in U.S. political process, which could inform legislation to strengthen national security and combat foreign meddling. The court also concluded that the subpoenas issued by the Financial Services Committee to Deutsche Bank and Capital One were adequately related to potential legislation on money laundering, this kind of financing and global movement of illicit funds through the real estate market. So again, that's just the synopsis here. I am just reading through a brief overview of this case. So this case was, the opinion was written by Chief Justice John Roberts. This SCOTUS held the courts below did not take adequate account of the significant separation of power concerns implicated by congressional subpoenas for the president's information. So I'm not going to hide the lead here, but the subpoena was inadequate and they reversed it. So letter A here. Historically, disputes over congressional demands for presidential documents have been resolved by the political branches through negotiation and compromise without involving this court. The court recognizes that this dispute is the first of its kind to reach the court, that such disputes can raise important issues concerning relations between the branches, that similar disputes recur on a regular basis, including in the context of deeply partisan controversy, and that the Congress and the executive have nevertheless managed for over 2 centuries to resolve these disputes amongst themselves without Supreme Court guidance. Such long-standing practice is a consideration of great weight in cases concerning the allocation of power between the two elected branches of government, and it imposes on the court a duty of care to ensure that it does not needlessly disturb the compromises and working arrangements reached by those branches. And we're citing the NLRB case here, quoting the pocket veto case here. Sub B, each House of Congress has the power to secure needed information in order to legislate, citing Doherty. This power is indispensable because without information, Congress would be unable to legislate wisely or effectively. Because this power is justified solely as an adjacent to the legislative process, it's subject to several limitations. Most importantly, a congressional subpoena is valid only if it's related to and in furtherance of a legitimate task of the Congress. The subpoena must serve a valid legislative purpose. So this is the test here when it comes to subpoenas. Furthermore, Congress may not issue a subpoena for the purposes of law enforcement because that power is assigned to the executive and the judiciary. Finally, recipients of congressional subpoenas retain their constitutional rights and various privileges throughout the course of an investigation. Sub C. The President contends, as does the Solicitor General on behalf of the United States, that congressional subpoenas for the President's information should be evaluated under the standards set forth in U.S. v. Nixon and Senate Select Committee and Presidential Campaign Activities v. Nixon, which would require the House to show that the requested information satisfies a, quote, demonstrated specific need and is demonstrably critical to a legislative purpose. So this is the other test. This is a different test that Trump was asking for. Nixon and the Senate cases, however, involve subpoenas for communications between the president and his close advisors, over which the president asserted executive privilege. Because executive privilege safeguards the public interest in candid, confidential deliberations within the executive branch, information subject to the privilege deserves the greatest protection consistent with the fair administration of justice. That protection should not be transplanted root and branch to cases involving non-privileged private information, which by definition does not implicate sensitive executive branch deliberations. The standards proposed by the President and the Solicitor General, if applied outside the context of a privileged information, would risk a seriously impeding Congress in carrying out its responsibilities, giving short shrift to its important interests in conducting inquiries to obtain information needed to legislate effectively. So they're saying that Trump's proposal would have some negative effects. The approach proposed by the House, which relies on precedents that did not involve the president's papers, fails to take adequate account of the significant separation of powers issues raised by congressional subpoenas for the president's information. The House's approach would leave essentially no limits on the congressional power to subpoena the president's personal records. A limitless subpoena power could transform the established practice of the political branches and allow Congress to aggrandize itself at the president's expense. These separation of power concerns are unmistakably implicated by the subpoenas here, which represent not a run-of-the-mill legislative effort, but rather a clash between rival branches of government over records of intense political interest for all involved. The interbranch conflict does not vanish simply because the subpoenas seek personal papers or because the president is sued in his personal capacity. Nor are separation of power concerns less palatable because the subpoenas were issued to third parties. So again, there was that question because they were asking the banks for the information. E, neither side identifies an approach that adequately accounts for these weighty separation of power concerns. So I'm pausing for a moment. So they went through what Trump's idea was, and they went through what the House committee's idea was, and they said they're both rubbish. All right, so they have to go in and design their own. A balanced approach is necessary, one that takes a considerable impression from the practice of the government, citing McCullough versus Maryland, and resists the pressure inherent within each of the separate branches to exceed the outer limits of its powers. In assessing whether a subpoena directed at the president's personal information is related to and in furtherance of a legitimate task of Congress, courts must take adequate account of the separation of powers principle at stake, including both the significant legislative interests of Congress and the unique position of the president. Several special considerations inform this analysis. So now they're going to set out the factors that have to be weighed before Congress can issue a subpoena to a sitting president. First, courts should carefully assess whether the asserted legislative purpose warrants the significant step of involving the president and his papers. Occasions for constitutional confrontation between the two branches should be avoided whenever possible, citing the Cheney case, quoting Nixon. Congress may not rely on the president's information if other sources could reasonably provide Congress the information if needs in light of its particular legislative objective. So if there are other sources. 2, to narrow the scope of possible conflict between the branches, courts should insist on a subpoena no broader than reasonably necessary to support Congress's legislative objective. The specificity of the subpoena's request serves as an important safeguard against unnecessary intrusion into the operation of the office of the president. 3rd, courts should be attentive to the nature of the evidence offered by Congress to establish that a subpoena advances a valid legislative purpose. The more detailed and substantial, the better. That is particularly true when Congress contemplates legislation that raises sensitive constitutional issues such as legislation concerning the presidency. And 4th, courts should assess the burdens imposed on the president by a subpoena, particularly because they stem from a rival political branch that has an ongoing relationship with the president. Other considerations may be pertinent as well. One case every 2 centuries does not afford enough experience for an exhaustive list. And so Chief Justice John Roberts has vacated and remanded. So those subpoenas were deemed to be reversed because there had not been enough consideration for the separation of powers. So we have this opinion delivered by Chief Justice Roberts. We had an agreement with Justice Ginsburg, Justice Breyer, Justice Sotomayor, Justice Kagan, and Justice Gorsuch, and Justice Kavanaugh. So we had a full court here, everyone agreeing, with the exception of Justice Thomas and Justice Alito that filed dissenting opinions. So we'll take a real quick peek again just to give you an idea of what the dissenter's opinion was. So I won't spend a lot of time on this, but Justice Thomas seems to feel that there were other motivations other than a legitimate legislative purpose. So that was really his emphasis in his dissent. And I can take you to the very end of it where he puts out exactly here. So this again is Thomas's dissent here. Congress's legislative powers do not authorize it to engage in a nationwide inquisition with whatever resources it chooses to appropriate for itself. The majority's solution of a non-exhaustive 4-factor test of uncertain origin is better than nothing. But the power that Congress seeks to exercise here has even less basis in the Constitution than the majority supposes. I would reverse in full because the power to subpoena private, non-official documents is not a necessary implication of Congress's legislative powers. If Congress wishes to obtain these documents, it should proceed through the impeachment power. Accordingly, I respectfully dissent. So he agrees that the subpoenas are no good, but he dissents because of different reasons. He feels that the rationale was incorrect. That takes us then to Alito. Here, and I'll just do a quick summary of his dissent. Thomas makes a valuable argument about the constitutionality of congressional subpoenas for a president's personal documents. In these cases, however, I would assume for the sake of argument that such subpoenas are not categorically barred. So he doesn't feel that they should be completely barred, that there are situations where it would be appropriate, unlike Justice Thomas. Here is Justice Alito's final word on his dissent. Specifically, the House should provide a description of the type of legislation being considered. That's a new piece, and while great specificity is not necessary, the description should be sufficient to permit a court to assess whether the particular records sought are of any specific importance. The House should also spell out its constitutional authority to enact the type of legislation that it's contemplating, and it should justify the scope of the subpoenas in relation to the articulated legislative needs. In addition, it should explain why the subpoenaed information, as opposed to information available from other sources, is needed. Unless the House is required to make a showing along these lines, I would hold that enforcement of the subpoenas cannot be ordered because I find the terms of the court's remand inadequate. I must respectfully dissent. So he again was against the subpoenas, but felt the four-factor test was not useful and felt, in his opinion, that Congress needs to report to the court what they're planning to do for legislation in order to get subpoenas, in order to get information. So apparently the Congress has to answer to the court, is Justice Alito's dissent. So there we go. There's the second dissent. With that, yikes. All right, so I'll take just a moment to show you the next couple of documents, everyone, to give you an update, and then I will turn on questions and comments so we can go through any of our immunity questions as we go through this. So let me just make sure I've got the right documents in place here. So here we go. Here's the first one. I will bump this back out again. Again, I will be turning on questions and comments here in just a moment. Just finish up this material. So quick update. This is a joint discovery report out of the Southern District of Florida. So this is, I believe it's the second one. The first one has already been filed quite a while ago. So this one just came out today here. There is not too much information. I will go through each of these pieces once I turn on the comments again because it is such a short document, but I just wanted to let you know that was filed today. And then to give you an update out of Georgia, we have a motion to compel discovery that was filed by Mr. Trump in Georgia. This was filed just yesterday. Again, this has to do with a letter and a back and forth between him and DA Willis. I will read through that again once I turn comments on here. And then the next one is the state's motion to take a deposition to preserve testimony of a material witness. And this is pretty typical. Sometimes when there's questions about whether there's an availability of a particular witness, the state will make this kind of a request. So this is a pretty typical request. And then the next motion was filed by Mr. Giuliani. Defendant Giuliani's motion to permit and require all co-defendants who have entered a plea in this matter to discuss the case with defendant Giuliani's counsel and or investigators. So he's requesting that anybody who's already pled out speak with his attorney as well as anyone who is investigating the situation. So I will walk us through these documents. Now, just as a quick side note, I will not be spending much time on these, but we do have President Trump's motion to dismiss on due process grounds here, which is lengthy. This was filed also. We also had a plea and bar motion to dismiss on constitutional and statutory double jeopardy grounds and supporting memorandum of law. So that was also filed by Mr. Trump. So these two motions were filed by Mr. Trump for dismissal, along with these other motions from various parties. So with that, everyone, I will go ahead and turn on comments so I can answer any questions that people may have and walk you through the language of some of these orders. There we go. Hello everybody. Welcome in. Welcome. Good to see you. Hello. Thank you. Oh, you're welcome. You're absolutely welcome. Thanks for joining me. Thanks for joining. Always appreciate that. Always good to see you all. Happy to answer questions. We had a lot going on today in the legal world. So Alito's unhinged. Right. I find myself needing to keep my opinions of Justice Alito to myself. I don't feel the same about Justice Thomas. So take that for what it's worth. Love the snowy nails. Oh, thank you. Yes, we had quite a bit of snow. So immune or not? Well, that's a great question, everybody. What do we think? Is he, again, these two cases weren't specific to criminal prosecution, but they gave you a pretty good idea of how the court felt regarding immunity to some degree, especially in criminal cases. So what do we think? Is he immune? Does he have complete immunity for any actions while he was in office? Criminal? No complete immunity? Right, no, not immune. Right. And there's quite a bit of case law to support that. It seemed too, even Chief Justice Roberts in his language was pretty clear in how he was setting it out. Yeah, and even, as I said too, even with the dissents and how they were written, it wasn't because there was this absolute immunity that was present that forbid the situation from occurring. That's not the reason why the dissents were in there. So that wasn't even set out in that way. Dog walk sour. Judge Pan was amazing. Oh my gosh. All three of the judges today were amazing. They were quick, sharp, right on the point. I thought they did an exceptional job. It was unanimous, right? The dissenting opinions were just aspects of it. Right. Well, when we look at it here, you can see specifically we've got with Ginsburg, Breyer, Sotomayor, Kagan, Gorsuch, and Kavanaugh joining the majority opinion, but we do have two dissenting opinions. So we're not split, like agreeing with the decision, but disagreeing with the opinion and how it's actually written, but that's essentially what happened. Can they easily change their mind? Curtis, that case was long for court. There was, I think everybody knew when they came in that was going to be one of the big ones. So for getting involved, and I've said it before, I'll say it again, the whole abortion situation, that entire situation needs to be codified, and the Rehnquist court knew it, and the Rehnquist court did what they could to keep that from happening. So it has to be codified in order for protections to be put into place. Can't read comments, white on white. Oh, here we go. Let's break up the white on white a little bit. There we go. We'll give it a little texture. What precedents this sets for future presidents? Well, hold on here, everybody. I'm kind of rearranging so we can see comments. Maybe if I just put it up a little bit. How about that? That way we can see it a little bit better. Okay. So, right, for future presidents, I mean, again, we already have the precedent in place. It's just a matter on whether or not the D.C. Circuit Court of Appeals is willing to take on this new test, this new way of assessing immunity that Trump is requesting. They can either say, yes, we are going to do that, or no, we're not going to do that. So, and then depending on what happens, we'll go forward from there. Was the Supreme Court dissent from today, or was it from a previous time? So those dissents were issued at the time the opinion was issued. So it was in July of 2020. I don't understand the dissent in this case. The dissents in the Mazars case, the dissents said the subpoenas were bad, but the court, in the majority court, said, you guys need to follow a test. If you follow this test, then we can go ahead and have subpoenas. The dissent said, first of all, the subpoenas are bad, and no, we shouldn't follow this test. Your test is bogus. We don't like it. And so even if you followed the test, we don't think it's good. So that's where we've got kind of these dueling things. Because what happened after the case, everybody, was that, well, first of all, Trump was out of office. And then the House committee went through and issued new subpoenas with new language, focusing to make sure they were in compliance with the Supreme Court's decision. And those subpoenas were allowed, and those records were gathered. So Thomas and Alito disagreed. They do not think that with the standard that was used, those subpoenas should have been allowed. That's where the dissents come in. They dissent just to dissent. I think, and they dissented in the manner in which the subpoenas could be issued, because the majority court said, look, you can have subpoenas. You just need to follow this test. Meanwhile, again, the dissents are like, no, we don't want that test. We don't think this is appropriate at all. Is this about his financials? Yeah, so his tax returns and those kinds of things. Mm-hmm. Yep, all of those were brought out in these lawsuits. It's getting to the point where judges are going to say, see, right. I agree, Navy. I really think that's the one of the better ways to kind of perceive this at this point, because we're not going to be surprised by Alito and Thomas with what they have to say. But when you look back through the decisions involving all the other justices, like there are 7 other justices, and you look and see how they've held in their rationale for it. Even Kavanaugh and Gorsuch, even though the very first case, they're like, we agree with the decision, but for a different reason. And they had just said, not because it's not okay, but there needs to just be a little bit higher standard. So, that's not a huge depart from the other justices on the court. So when we're looking to see what's going to happen, you can kind of say, well, if they, go along with what they've done before, then you can kind of predict how they will fall in line. But, the thing is, there are a bit wild cards, a few of them. And so we don't know if they're going to stay in line with themselves or go crazy. Yes, law education, everybody. Kavanaugh should be a slam dunk. Oh, Kavanaugh's not a slam. I wouldn't say any of our new justices are slam dunks, honestly. They go back and forth. I am still trying to figure out how to follow them. They have their own particular ways of viewing certain things, but if it's not within that category, it's hard to tell which way they're going to go. Loose cannons, perhaps. I think they're just, they're not, it's good and bad. It's bad because it's hard to really predict what's going to happen, but it's good because each one of those justices, each one of the new justices has said in their own way, in certain kinds of cases, like, look, I understand the majority went this way, but I'm not going with the majority. And sometimes that means going against, a conservative majority. And they have done that. Gorsuch has multiple times ruled against the majority and said, no, this is inappropriate. Kavanaugh as well. And Amy oh my gosh. I call her Amy, but that's so disrespectful because I forget her last name. Help me out, everybody. What's her last name? Help me out. Is it Bryant? Brian? Barrett. Thank you so much. Oh my gosh. Barrett. Okay. I knew a Bryant, and so that's why I got mixed up. Okay, Barrett. Coney Barrett. Thank you very much. Okay, Justice Coney Barrett. Yes. So she's not just Amy. She's Justice Coney Barrett. But she's also kind of, if you listen to the questions she asked during some of the oral arguments, some of the questions she's asked, I've been like, well, yeah, great question. Excellent point. So she's incredibly intelligent and incredibly well-spoken, incredibly well educated. Her writing is exceptional. Do I disagree with a lot of the stuff that she goes with? Yes. But I also see huge potential in her as well, just as accomplished and good justice. I think she definitely has that potential there. I think we're all a bit rough to start with. If immunity is granted, what would President Biden be forced to do? So what? Like absolute presidential immunity against criminal acts? I think at this point, we can take a moment and say, what do you think Biden would do? I mean, if Biden was given unlimited or complete immunity for anything he did while he was in office, what kind of a choice would he make? What decisions would he make? Would he do whatever he wanted to do because he could get away with it? Or would he just keep doing the job? I think that's the question. Forgive student loans. That could be Gabby. He was pretty hard about that. Yeah, I mean, he would get up, he'd go to work, and he'd go home. That's what he does. Yeah, keep doing the job. And I think that's what, again, you have to ask that. What would any of the candidates do? What would Nikki do? Or what would Ron do? What do you think they would do if they were given immunity? And I think in a lot of the situations, I think the answer would be, they would go and do the job. But maybe that answer would be different. Well, we can't be president for life because of how the Constitution's written. And you can't just dissolve the Constitution just if you get into power. But there are ways and infrastructure and powers that could make things very difficult for a lot of people. Well, yeah. Would immunity abolish impeachment? No. And one of the big arguments that Trump's attorney said today had to do with impeachment. They go hand in hand. So you could not get rid of impeachment, just like you could not get rid of the executive branch. I mean, they go hand in hand. How long do you think before the decision is made? Cheryl, I think it'll be done pretty quick. I really do. There's so much precedent here. The judges today were quick. They were quick on their feet. I think they will get an opinion and order out pretty soon. It's not good for anyone, no matter how good the person they are. True. I agree. I agree completely. I agree. We've got to have a check. We've all have to have checks. Do you think the Constitution's a living document? Well, I mean, it's a book, so I don't know. I mean, I kind of, the way I put it is I see it as a skeleton. It's, the start, but we add on throughout all the states and all of the other statutes and law. We add to it to make it into a body. So that's kind of, I suppose that would be a living thing, right? If it created a body, I suppose. I don't know. Wow, that turned really esoteric. This was a real buffoon from, yes. Oh, well, Hawk's not wrong. He's not wrong. On this, I withhold judgment for anything else. But yeah, it wasn't as strong as it could have been. Now, SCOTUS does have a check. It's just not a very strong check. And right now they're pushing their boundaries, much like a teenager. So Congress is the check. And, that has come into play several times. Used today, turned it in a fundraiser. Yeah, I saw that. That's unfortunate. Take away the bronzer. Yikes. Constitution's the foundation. Yes, I think so. It's where we start. But when's the next Hawk? Well, he's a busy man. He's got trial coming up. So we'll have to, I'm just going to kind of stay low until he's ready to come back out again. When you are a litigator, and you go into trial, it takes over your entire life. Like, it completely takes over your world. You forget to eat, you forget to sleep, you forget to, brush your teeth. Like, you are so into it, and then you collapse and you just don't exist for a while. And then you come back and do it again. A Cletus life, that would be so funny. Oh my gosh, that would be so funny. Imodium every night. I saw that. I didn't realize that was something people didn't realize that we do. I mean, it's a stressful job. It's really stressful putting on trials. And every attorney, we have our own techniques on how we deal with it. But yeah, I mean, we're humans. Oh my gosh. Why would they not? Well, that's a great question. Why would you not unalive someone? Maybe because it's wrong, right? You wouldn't do it because it's the wrong thing to do. So as opposed to this question of could you, the question would be, should you do it? And you have to figure out the kind of person that would fit in that role for that answer for you. Yeah, how did we let it go? Oh my gosh. Yeah, I mean, again, there's lots of things that are legal, but I wouldn't do them because they would go against my own code of ethics. So when you say make things hard for certain people, is this covered by project? Yes, Alex, exactly. That's exactly what I mean. The the infrastructure is in place for that. They already have a lot of the different things set. They just need, the key to turn it. paralegal for 25 years. Can be stressful for sure. You know what I'm saying then, K. Rush. You know what I'm saying. You know it. Oh my goodness. Morals don't normally have to be learned. Well, I don't know. I think it can be lots of different things. It can be, a sense of right and wrong, but, sometimes those senses are muted. So then you have to learn. And then if you learn right and wrong, are you better or worse than someone that just instinctually knew it? I don't know. I don't know the answer to that. Who's the key? Yeah. Well, I think the key is out there somewhere. Yikes. So, did you all want me to go through then these orders or the reports here? They're very short. Each one of these is very short, but I wanted to make sure to go through them for people who would like to hear what's going on with them. Advice for 1 year. We do. Oh, yeah, for a 1L con law student. Oh my gosh. Okay, Carly. Well, there's a couple of things. First of all, your teacher's going to be ridiculous. All right. It's just true. Okay. First year con law is just ridiculous. It's like, why are we spending 8 weeks on Marbury versus Madison? Why is this happening? And I get it. Lujan's important, but why are we spending 2 months on it? There's stuff I want to know. All of the equal protection and amendment bits and bobs, those are in your second part of con law. They're not in your first. So the most important thing in con law 1 is to stay awake, take decent notes, and just know everybody has to go through it. It's a rite of passage. But once you're on the other side, you'll be a better attorney for it. Where can I find these documents I like to print? Oh, absolutely. So we'll start here with this Florida document since it's right on top. So we have at the very top, let me just make sure I'm lined up here, everybody. I know it's kind of hard to read those comments down there. That was such a good point, so I'm going to try to push this up a little bit. So here's the case number out of the Florida case. We have case number 23-80101-CR Cannon. So if you put this case number into any search engine, it will pull up lots of different sites with different dockets set out. There's several that are really good. Personally, I like Court Listener. I think they do a really good job, but there are lots of other sites tracking all of this as well. Sometimes if I'm not really getting what I want, I'll go into the court system itself, but that's a lot of extra work. But typically you should be able to pull it up, and then whatever kind of order or report or motion that you're looking for, you can click on whichever one it is and it should pull it up for you in a PDF. You're welcome. Absolutely. Yes, this is Judge Cannon. Judge Cannon. Disaster define. Yes, Maricopa. I tell you though, Fulton County, quite frankly, people, like, there have been a few times where, I'm like, I don't know if I'm going to make it. It's been frustrating. Bing is not good with the documents. Really? Oh, that's good to know. That's a great heads up too. Yikes. All right, let me take you through this one. So we've got the second joint discovery report. So in accordance with the court's order on November 10th of 2023, the United States of America files this discovery report. That order contemplates a joint discovery report being filed, but as the defendants have yet to produce any discovery, oh dear, the government has prepared this report as they did the last time. I think they said the same thing the last time. They said, well, defense doesn't agree, but they're not disagreeing either, so we'll just file it. That's so funny. Counsel for the defendants have reviewed this report and agree that it's consistent with the representations the government has made to the defense when producing discovery. That's like the most law sentence ever. Oh my gosh. The government has made 8 productions of unclassified discovery. The government described the first 5 of these productions in the first joint discovery report, as well as its responsives to the standard discovery order. The government has made 3 productions of unclassified discovery since the first joint discovery report as follows. So here we go. Production 6, consisting of 1,900 pages of documents, which was provided to all the defendants October 6th. The production included inter alia memorialization of recent witness statements and materials the government had recently obtained from the National Archives and Records Administration, also known as NARA. Again, this is just 2 pages, so I'm not doing a sticky note for this one, but I will for the others. Production 7, consisting of about 138 pages of documents, which was provided to all defendants on October 16th. Documents were produced in response to an October 9th discovery letter from defendant Trump, notwithstanding the government's belief that the production exceeded its current discovery obligations. All right, hold on. I am actually going to label this. I just took a look and I was like, oh dear, we're gonna have to take a little bit of time to go through this. So let me just label this real quick before I move too far away. Okay. I think my cat took my pen, everybody. Oh dear. Nope, I found it. She buried it. Oh my gosh. Okay. Oh my gosh. All right. USP Trump. This is a Florida case update. All right. Florida update. Oh my goodness. There we go. That'll help keep everybody. She's innocent. No. Say nothing. White collar crime. Oh my gosh, that's so funny. All right. So this should help anyone joining us. They should be able to catch up. Here we go. Oh my goodness. Here we go. So next we've got production 8. Consisting of about 2,000 pages of documents, which was provided to all defendants on December 6th. The production included, inter alia, material previously produced in classified discovery that is unclassified or for which the relevant equity holder have determined that the documents no longer need to be protected through classification and have declassified them. So it's another category of documents. I love your lives. Oh, thank you. Thank you so much, Grandma Dude. Always good to see you here. Always. All right. As recounted in the first joint discovery report, September 14th, the government had provided to the defense by early September 5 productions of unclassified discovery totaling about 1.28 million pages, as well as all CCTV footage obtained by the government's investigation. Then we have footnote 1 here. Mr. De Oliveira's counsel has raised periodically with the government certain questions relating to technical issues with viewing the CCTV footage. The government has promptly assisted with these inquiries, including by providing counsel a laptop for viewing the CCTV footage. Oh, well, that's nice of them. On January 5th, so just a couple days ago, Mr. De Oliveira's counsel raised with the government additional such issues with which the government will endeavor to assist. Okay. That's generous. In sum, since that time, the government has provided to the defense 3 productions of unclassified discovery, totaling about 4,000 pages. Thanks, Maggie. The government has also made 7 productions of classified discovery, the first of which the government described in the first joint status report. The September 13th production described therein consisted of approximately 2,600 pages. The 6 productions of classified discovery made between September 28th and December 6th consist of approximately 3,000 pages and have been described in prior filings. The government is aware of its continuing duty to disclose additional information as required by the Standing Discovery Order, Rule 16C of the Federal Rules of Criminal Procedure, which is this. Oh my goodness. And the Brady and Giglio case and the NAPU and the obligation to assure a fair trial. So they're saying they are within their compliance requirements. Respectfully submitted, Jack Smith as special counsel. So there we go. That's the update then for Florida, everyone. Joint discovery has been filed such that it was, I think joint would be a generous term, but there you have it. Nevertheless. Oh my goodness. Short and to the point. Yep, exactly. So the other motion that I think would be interesting to go through again, we've got this motion to compel discovery that was put in by Mr. Trump. We can do Giuliani next, but this one actually goes through a couple of communications with DA Willis, and maybe we can make an assessment as to whether or not we feel like the discovery is appropriate or not. So let me label this one here real quick, and then we will catch this one next. Divorce is getting expensive for the people. It really is. It really, and we're all going to need therapy. We're all in the middle. Oh my goodness. All right, a Georgia case. Georgia RICO case update. I'll just give it a general label here so I don't have to change it with each document, just to give people an idea. How would immunity affect Trump's court case? So for Georgia, if you're talking about Georgia, so part of the thing that he's been charged with, right, is conspiracy to retain power. That's the ultimate goal. So if he's somehow given complete immunity for all actions he did while he was in office, for any kind of criminal actions, then I would say anything that was seen during that particular period of time might be able to be seen as immune. But I think the big issue, once that would happen, is if immunity did check into place, there would be a question of what was presidential and what was not presidential. So that was the other issue that was involved. Is something impeachable? And if it's not impeachable, then you can't charge it. But if it is impeachable, you can charge it. So there is that other question too. So it's hard to know exactly. Hard to know. Dangerous precedent. Yeah, yes, indeed. All right, here we go, everyone. We've got a motion to compel discovery, again, filed by Mr. Trump. This was just filed yesterday. And you know it's been filed by him because he refers to himself as President Trump. So President Trump files this motion to compel discovery, and in support shows the following. Number one, on December 5th of 2023, the undersigned lead counsel emailed the following discovery request to Fulton County District Attorney Willis. Madam D.A. Willis, attached is a letter written by you to former Chairman Thompson dated December 17th of 2021. This letter represents an official request from you for access to records that may be relevant to your office's criminal investigation. What you sought is set out in your letter. Please provide me with former Chairman Thompson's response to your December 17th letter and any further correspondence between him, the select committee, your office, and you. So now we're talking about Congress. D.A. Willis's letter to then Chairman Thompson is attached as Exhibit 1. In a follow-up email, undersigned counsel asked whether former Chairman Thompson or the Select Committee sent a written response. The DA's office has steadfastly refused to answer yes or no to whether former Chairman Thompson or the Select Committee ever sent a response to D.A. Willis's letter. Accordingly, President Trump requests this court compel the DA's office to respond yes or no to his request, and if yes, to disclose all responses. So there's number one. First, you need to answer, and then you need to give me this thing if it exists. Yes, Tori, I was, Tori. I think that's a fair statement. On December 27th of 2023, in an email response to a question from co-defendant Clark's counsel, ADA Young, wrote in pertinent part, Attorney Dugald, here is the answer to your question. What does it mean on the state's witness list when it says, with respect to Donahue and Rosen, video presentment review? As to Donahue and Rosen, the jurors reviewed the video of their testimony. They did not appear before the jurors in person. On that same date, in response to that email, undersigned lead counsel emailed the DA's office. I'm sure I missed it in discovery. I did not see any videos on Donahue and Rosen. Maybe you could point out where they are in the discovery. The DA's office did not respond because they're in the middle of a homicide trial. On January 2nd of 2024 at 8:45 a.m., undersigned lead counsel again emailed the DA's office. Please let defense counsel know if the video of their Donahue and Rosen testimony has been produced in discovery. Thank you. The DA's office did not respond. On January 3rd at 7:42 p.m., so that was like 24 hours, 24 and a half hours later, undersigned lead counsel again emailed the DA's office. Once again, I respectfully request that you inform defense counsel if the video testimony has been produced in discovery, and if so, where it is located. Please be advised that if your office continues to choose not to respond to this request by noon on Friday, January 4th, I will assume that you do not intend to respond. Wow, everybody, look at that. Oh my goodness. And will have no choice but to file a motion to compel, as defense pretrial motions are due on Monday, January 8th. The DA's office did not respond. Accordingly, President Trump requests this court to compel the DA's office to disclose if the video of Donahue and Rosen's testimony reviewed by the jurors has been disclosed to defense counsel in discovery, and if not, to disclose the video. Respectfully submitted, this dude. Oh my gosh. Where do they get these time frames from? Yeah, it's a great question. I'm not sure. I'm like, they're not responding quick enough. And, you know, you do have to really chase attorneys down. I'll be the first to tell you that. You got to chase them down. If you don't chase them down, they will put out the fires first. So you have to, you know, be on fire in order to get taken care of. I acknowledge that. But on the other hand, you know, like you just be reasonable about it. She's doing one trial right now. At least one. Yeah. I mean, their docket is so busy in Fulton County. I mean, my goodness gracious. There's all kinds of stuff going on. Do they have to tell them where it is? Well, first they got to sort out what they're talking about. And then if they do have those, I mean, that kind of evidence the state should give and the government should give. Are they required to? That I don't know under the specific rules of Brady in that jurisdiction. But should they? Yes, it should all be given over. But the time frame on when it should be given over, that's a different issue. I mean, as long as they're being appropriate about it. Isn't that doing their job for them? Well, you know, we give over everything. What was up with the filing from the co-defendant about Willis and Ward? Yeah, so that was unfortunate. So as to both those questions, everyone. So I think, you know, we've got the Brady rules, so any kind of evidence needs to be given to the other side. So that's the one thing. But what they shouldn't be doing is saying, you know, and within our time frame, not, you know, according to our schedule, or else we're going to file these motions to compel. That to me is out of line. I think that to me is saying, look, I'll give you everything, but I'll give it to you as soon as I can. I'm not going to do it according to your schedule. You're going to have to, you know, get yourself sorted out. I think that's a really good point. But, and then I forgot the second question. Oh yeah. So the second one, everybody, was that there was this motion filed, and I've got it here. Let me see. Where did I put it? At least I think I have it. Oh, I do. Yeah. Ugh. I have it here. So this was the other, one of the other motions that was filed here. This was filed, by, oh, thank you, Desert Skies. That's so sweet. This was filed yesterday by Mr. Roman's attorney. Now, I did do a quick post on this earlier, so, you know, there's that. But they're basically, oh my gosh, this motion, I tell you, for goodness sake. So they're basically saying here that there was some kind of an improper clandestine personal relationship during the pendency of this case between, DA and the special prosecutor. Now, I don't even know their names. I haven't even taken time to learn the names because I don't care. I really just don't care about that. But they're setting out here that the special prosecutor has a special relationship apparently, and that they're somehow profiting from it. Again, as a prosecutor, you're not profiting from anything. There's no profit as a prosecutor. That just doesn't happen. It just doesn't. But they're putting it out. So they're saying, what I found really interesting about this case is instead of saying, you know, like, oh, there's problems, we have big issues here, they said, they're putting it in this weird format. Like, who does this? So, nevertheless, the district attorney's fame and power do not change the fact that she decided to appoint as the special prosecutor a person with whom she had a personal relationship and who is now leading the day-to-day prosecution of this case. And so, again, they're trying to say that everything needs to be to get tossed out because of this relationship that these two may or may not have. And so then the next part, they're saying, well, the court may well be wondering, and for good reason, how do you know this? And why does it matter? Like, are we writing fan fiction? What's happening here? Why is this happening? Why is this written like this? You know, I have questions too. So then they set up these ridiculous questions. How do we know this? Well, let's take a look. Let's take a look at how they know this. Open records request to Fulton County revealed the district attorney did not obtain county approval to appoint the special prosecutor. Why would the district attorney not obtain this approval prior to appointing the special prosecutor? All right, this has already been litigated and discussed with prior defendants. It was already taken care of. So that's done. This has already been dealt with. The special prosecutor has admitted his oath was not filed prior to his work on this case. They actually addressed this in a hearing. Judge McAfee was like, look, this is this and this is this. Let's move on. So those are two things. And the next bits are a little bit odd to me. Let me know what you think. I'm curious to get your perspective too. The special prosecutor is seeking a divorce in Cobb County and sought successfully to seal those records, hiding them from public view. Why would a private citizen such as the special prosecutor shield findings related to his income and spending from public view? Like, that just seems totally inappropriate. You're going after somebody who's getting a divorce who asked for their records to be sealed. Like, what? Like, how is that okay? Yeah. How is this okay? Because he or she, I don't know. I don't know who we're dealing with here. They had a boom. Yeah, I have no idea. Yeah, it's none of their business. Why would a divorce matter? Exactly. I mean, to me, this seems like, what are you talking about? This seems irrelevant. This would be a 401 objection. All right, for relevance. So next, while the filings in the divorce case are sealed by the court, so they're acknowledging they don't have that information because it's sealed, the legality of which is open to question, which is just rude. That's just rude on why you can have your divorce sealed or not. Like, wow. Information obtained outside of court filings indicates, so we have no idea what this means. What kind of information from outside court filings? Well, what do you mean? Like, you have like phones, like faxes? What kind of evidence are you talking about? And they're indicating that the district attorney and special prosecutor traveled together. What does indicating mean? Like, you have the receipt or what? Or it's saying, you know, they may have traveled north. You know, what are you talking about? It's a lot to me. It seems like a lot. Now, I don't know what all the rules are when it comes to, you know, interpersonal stuff. You know, I don't get involved in all of that. Every jurisdiction's a little bit different, but, you know, you're not going to be able to just say you need to throw out a RICO case with 19 defendants because there was some kind of prior relationship between prosecutors. Like, what are you talking about? And I have no evidence of it. So just take my word on it. Just take my word that they somehow decided to go to the Caribbean together. Or that someone may have seen them in private together. We don't know who, we don't know where, we don't know how. Sources close to both, as we all know, that's where we get our tabloids, right? Sources close to both, all right? Whatever. According to these sources, the personal relationship, again, according to who? Who are your sources? And what are you even talking about? How do they even know what their personal relationship is? So it's a lot. The Trust Me Bro defense. It's a lot, but I've not seen it pled so blatantly out in like this kind of bulleted outline format. Like, here's another piece of hearsay. Here's another piece of someone's guess. Here's another rumor going around. And then let's put a bullet point in front of it and add it to a motion. Like, what are you people doing? So I found this frustrating, not because of, you know, the idea that you can't raise legal issues. I find it frustrating when you're presenting it in a way that is so clearly, blatantly biased. And I'll show you probably the last piece for me that was really frustrating was here. The undersigned counsel knows the special prosecutor and has researched his litigation experience. That sentence right there is just tossed out my, the credibility here. So I know this guy and I know his history, and there's no way he's qualified to be on a case like this. Like, what? What do you get to do? That's not right at all. Yeah, I don't know what Fani will do. I don't know what is required. I mean, it is a motion now. It's a motion filed in court on the docket. So, she will need to file a response to it. That's what's required. They're asking it to be set for a hearing, and maybe it will be. I really don't know. But if I'm looking at how to draft a motion, this is not it. This is, putting all of the rest of it aside. It's like, give me some evidence. If you want me to follow you and believe what you're saying, give me some actual legitimate evidence. Not just somebody said something about somebody else who saw somebody behind a trash can. Come on, what are we doing here? We're in a court of law. Yeah, it's a good question. I don't know. I mean, if there's again, don't get me wrong. If there's something going wrong here, if someone's not doing their job, that's what your job is as a lawyer, is to call them out on that. Absolutely. But if you start getting into like this personal zone of, well, why did he seal his divorce? Or, what kind of relationship, what kind of trip did they go on? Like, what are you talking about? Let's all file amicus curiae, say we've dated. Oh my gosh, VC genius. VC, I love that. I'm going to send a letter. Oh my gosh. I mean, come on. This is when you get desperate, when you start getting petty like this. It's like when your case is bombing. And I can say that wholeheartedly with full and complete understanding of defamation and how it works. All right, so I feel like this case is getting, I know it's getting a lot. So here's the last one, everyone. Then as I close for tonight, we've got to go through Giuliani's motion here. I can't leave you hanging on Giuliani's motion. No way. No how. So we have this last motion. Oh my gosh. At this point, everyone, I don't even remember how many times I've been live today. Is this my third live today? I think I went 3 times. I've done 6 lives in 2 days. I'm going a little bit bonkers. Oh my gosh. All right. So, this is the Georgia RICO case. Again, I'm just writing out my little sticky note here so we don't get mixed up. There's just so much going on right now. It's a lot. It's just a lot. This has been the third. Okay, thanks, Navy Vet. I appreciate that. I'm glad somebody's keeping track. For me, there's just so much going on. I'm running around like a chicken with my head cut off here. So, and this is Giuliani's motion. So let's go through this one for tonight. Is he planning to give his own closings? I don't know. I hadn't even heard that. Yikes. I would not recommend that. I really, really would not recommend that. Whoever's giving their closing argument should have been determined before trial starts. I mean, sometimes you need to make changes, but that should have already been assessed. He did say that? All right, well, oh, my goodness gracious. Lol, Frank, you're not just whistling Dixie. All right, here we go. So let's go into the Georgia RICO motion here. This is Defendant Giuliani's motion to permit and require all co-defendants who have entered a plea in this matter to discuss the case with Defendant Giuliani's counsel and or investigators. Here we go. Whereas Defendant Giuliani's co-defendants, Jenna Ellis, Kenneth Chesbrough, Powell, and Hall, have each entered guilty pleas in the above-styled matter. And whereas it appears that a condition of the co-defendants Ellis's, Chesbrough, Powell, and Hall's plea agreement is to provide that they are not permitted to communicate with any other co-defendant concerning the facts or circumstances of this case. But before we go too far, we've got to hit this monster of a footnote here. So let's bump down. For example, in the plea colloquial, sorry everybody, it's getting late. In the plea speech with Jenna Ellis on October 24th, the Superior Court of Fulton County, Judge McAfee recited the terms of Ellis's plea to include a resuscitation of the plea conditions by the Assistant District Attorney that she, quote, testify truthfully at all hearings or trials involving co-defendants, and that she have no communication with co-defendants, witnesses, or the media until all cases have been closed, and that she must continue to provide additional recorded statements and affidavits to the state as required, that she must continue to fully cooperate with prosecutors, including but not limited to participating in interviews with prosecutors, appearing for evidentiary hearings, and assisting in pretrial matters. Judge McAfee further imposed the following condition. Ellis is not to have any contact, either personally or through other agents, with the media or any co-defendants or witnesses. That's important. Oh my gosh. All right, so there's footnote number 1. And next, whereas it appears that a condition of co-defendants Ellis, Chesbro, Powell, and Hall's plea also requires they cooperate with the Fulton County District Attorney's Office and participate in additional interviews and assist the state in pretrial matters, and whereas pursuant to Georgia Code Section 17-16-4A1, statements on co-conspirators that are attributable to the defendant must be disclosed as if the statements were made by the defendant himself, and to avoid the obligations of discovery. In Georgia Code Section 17-16, the state must show that there is substantial threat of physical or economic harm to a witness, and whereas under Code Section 17-16-6 authorizes the court to order the state to permit the discovery or inspection and interview the witnesses, the purpose of the disclosure of witnesses prior to trial is to prevent a defendant from being surprised at trial by a witness that the defendant has not had an opportunity to interview, citing case law. Further, even where the judge allows an exception to the disclosure of a witness's information prior to a trial for good cause, which has not been presented in this case, nevertheless requires that counsel for the defendant be afforded an opportunity to interview such witnesses prior to the witnesses being called to testify. Where the Supreme Court held where there is no tangible evidence to be produced in discovery, the lapse of information or perceived lack of fairness is remedied by allowing the defendants to interview the witness at issue. Georgia law provides trial courts with substantial discretion to ensure compliance with discovery, including the interviewing of witnesses, even going so far as to permit an exclusion of the witness in the case of prejudice and bad faith, citing case law. The opportunity to interview witnesses prior to trial is the bare minimum that's required by Georgia law. Prohibiting interviews with counsel for co-defendants is in the direct opposition to the plain language of the statutes and the clearly stated policies and purposes of the discovery rules. And whereas it's necessary that counsel for defendant Giuliani be able to interview co-defendants Ellis, Chesbro, Powell, Hall, in part because their video proffers have raised questions about the content and completeness of their individual statements, and whereas counsel for defendant Giuliani has previously reached out to the district attorney's office via email with questions about the proffer videos, and these questions have to date gone unanswered, and whereas counsel for defendant Giuliani will be unable to properly investigate the facts of this case or properly advise defendant Giuliani about the potential evidence in this case unless they are able to interview co-defendants Ellis, Chesbro, Powell, and Hall. Wherefore, defendant Giuliani hereby prays that this court enter an order not only expressly permitting but requiring that co-defendants Ellis, Chesbro, Powell, and Hall be made available for interviews with the defendant's counsel and/or investigators for purposes of discovery. Defendant Giuliani hereby further requests that this honorable court schedule a hearing to determine the merits of this motion. This 8th day of January 2024. Wow, that was very well written. Good job. Good job. Well written. Necessary? I'm not sure. But was it well written? Yes, it was. Excellent work. Where did he get all the money? Yeah. Yes. So, yes, a prayer, everybody, is just old school language. Some places require it, some places don't. It depends on which form you use. But what we call, when we're asking the judge to do something, we're praying for it. That's the term that we use. So you put it in your prayer. You have to make sure that you're making that request of the judge. So we just call it that. It's a term of art. I don't know what's a term of art, but whatever. That's what we call it. I don't know why. I don't know why, But yeah, I don't know. This one I thought was really well written. I thought it was nicely written. When you're shocked that it's well written, I know. I thought it was, pretty. This is pretty textbook. This would be a textbook motion. In my class, you would get full credit for this. It was well written, no typos, well organized, stated clearly, proper citations. I would double check the citations before final grade, but yeah, I would get full credit. Yes. Funny jargon you got, true. Minus the Well, this looks like it's a direct quote, so I think that's why, that's why it's included. Yeah, I think it's a direct quote. I think that could have been done a bit differently. But there you go. It seems like we're having some problems with we're having some communication issues between the attorneys at Georgia, everybody. I think that's the lesson that we're learning for tonight. Hope and prayer, because it was only help at this. Yeah, it's carried on from old school times, and a lot of our traditions, we kind of have some of them, but not that many anymore. So most people, we don't use that term prayer anymore. And unless you're in the business and you've been in the business for a really long time, you may not even know what that means. So I'm sure there's a much more up-to-date thing like court request instead of prayer that we say, but it's something that's just historically what we do. So many attorneys. Oh my gosh, there really are. There really are a lot. There's a lot going on in the RICO case. There's a lot going on. A lot more of you sane people. Oh dear. Well, there's different kinds of sanity, right? Oh my goodness. So with that foreboding moment, let's take a peek at the calendar. Oh, what's going on here over the next few days? So I will not be able to pop on tomorrow. I've got a very busy day in my own world. in my world that doesn't involve this, I will be out. Oh my goodness. Oh, thank you. Thank you so much. That was adorable. But I will be back for sure, everybody, 7 p.m. Central Time on Thursday. So I will be back at a minimum then. I'll probably come back on earlier in the day. So we do have closing statements for the civil New York case. I am planning to do a post or a quick live going and reviewing the case again. I'll probably do a post on it just to remind everybody where we're at, but we've got closing statements coming up on Thursday. We're not presenting any kind of evidence. We're just making arguments. So, glass slippers. Thank you. Thank you very much. So I will be coming back on at some point for that. And then, of course, we've got to go through what those closing statements were like. We've got still some filings that are being put into the New York docket to close it up. Now, Judge Ingron has said he will have a decision for us by the end of the month, and I have no doubt that that will happen. So we'll keep going forward on that. Now, this is a soft date in the Florida case regarding expert witnesses. This may or may not need to actually happen according to the deadline. But the big thing, everybody, the huge thing where we're going to turn a corner, where I will be focusing for the next few days, will be on the Carroll cases. So we have Carroll 1 and we have Carroll 2. So I have put together everything needed in order to kind of break those two cases down to take everybody through the process, because we're at a point where we are pulling in a jury and we're asking for damages. There was several rulings that came out, and actually I think there was a ruling just today that just came out also here. So was it today? Yes. So we just had an order, a memorandum and order on the plaintiff's motion in limine. So there were several requests made by both sides, but several requests regarding what kind of language could be used in front of the jury, because of course it's such a sensitive issue. And the judge has issued the order here, and certain terminology is not allowed to be presented to the jury. They're not allowed to hear Mr. Trump argue that he didn't do it. Those kinds of things are not going to be permissible. They're going to be excluded. So he's going to have to figure out how to get through his case without using these words and using these kinds of strategies because they have been eliminated via court order. So this, I will be breaking this down and going through this along with where each of these cases are. We do have the Court of Appeals that gave us a decision regarding presidential immunity too on this civil case. We've got that, but there's just a lot going on these Carroll cases. So I will be spending quite a bit of time here and here going through that. And of course we have our sub chat Sunday evening. We will have that coming up as well. But so I'll be focusing primarily on the Carroll cases just to get everyone ready for what's going to be going on here. I'm not it's not going to be, I would highly doubt if it's televised, but it's going to be all over everywhere. So in order to have a really good idea of what's going on, I think it's important to go through that. So we will go through that. I will get us all prepped up for that trial. We'll do trial prep together, everybody. Do a little bit of trial prep. We also have the Iowa caucuses on the 15th, right? That's huge. That's a huge moment. That kind of snuck up on us quick. So that's also coming up on the 15th. We also have a Florida defendant motion to compel that is due as well. So lots going on. The first brief for SCOTUS then on the Colorado case is due on the 18th. So the actual petitioner has to file their brief along with amicus briefs need to be filed. I think that's right. Nope, just amici. Sorry, my bad. The amici briefs are on the 18th. The petitioner's brief is on the 31st. But the first sets of briefs then will be seen to SCOTUS on the 18th. So they've got a whole, bunch of time here in order for those briefs to start coming in. So that'll be coming in. Then we have the brief on the merits due on the 31st. Again, that's for the Colorado case in front of SCOTUS that will be coming up. So I do plan to also set aside time to do the post-election cases. That's set up. We've got a super live that I'm putting together going over the 14th Amendment cases, all of them. We've got new ones filed in Illinois and Massachusetts, and we haven't reviewed the Michigan one. We've reviewed lots of the other cases, but we've not reviewed Michigan. And I just pulled Minnesota again as well. So we'll go through that. We also have a couple of Supreme Court cases regarding their kind of their shadow docket or that have just been agreed to here on the Mifepristone case. I'm going to say that name wrong every single time, but that's having some movement there. There are also a few other cases going on regarding those issues too. So I'll probably bring you up to date when I hear anything on that as well. What days is he mandated to be in court? So technically unless a judge tells you you have to be in court, your only requirement is in a criminal case. If you have a criminal case going forward, you need to be present because of the constitutional requirements that you can confront people in court. So you have to be in court for that. That's required, but for civil cases, you don't have that same kind of right. So that requirement is going to be there only if the judge is requiring your presence. But in our criminal cases, you have to be there. I would be shocked. I would fall off of my chair in shock if he did not come in for Carroll damages either. He's going to want to be in these civil cases because he has a way that he likes to present himself to anyone making judgments on him. So I have no doubt he will be there. And then also that takes us into February real quick, everyone. We have our pretrial motions in Georgia due on the 5th in February. Response to the SCOTUS brief is due here. We have a reply due. We have oral arguments on the 8th. The omnibus hearing for the New York criminal case. So this is the hush money case. So on the 15th, we'll have a good idea on when that New York criminal case will actually be going. We'll hear about that by the 15th without a doubt. And we have Section 4 motion hearings in Florida. They're scheduled for 2 days, the 15th and the 16th in Florida. And then the following week, we've got pretrial motions due in Florida. So we will see how those come out as well. We've got a lot going on, everyone. It's going to be busy. And then, of course, March, we just don't really know at this point what's going to happen. Criminal case in New York. In my opinion, I think the criminal case in New York will still go. I think the DC case will get pushed into April or May. And I think the New York will stay where it's at. And I think it'll only take a week or two and then it'll be done and we'll have a verdict in New York. Could we hear this week or next on the DC appeal decision? Absolutely. Absolutely. This isn't going to be a really complicated case where they have to go through, meticulously with a fine-tooth comb, all of the amicus briefs. I've already gone through the amicus briefs. They're easy reads. And for these justices at the level of their intellect, I have no doubt they'll be able to get a decision to us pretty soon. Absolutely. Absolutely. So I've got a lot of, wish I could attend the court hearings. Yeah, I think a lot of it will be televised, but a lot of it, you have to really rely on the people who can physically be there and then report back as accurately as possible. So there are a few different ways of going through that. Oh my gosh, look at all those likes, everybody. Well, thank you so much for that. I appreciate that. Sincerely, I sincerely do. So with that, everyone, as far as my third live of the day goes, I will go ahead and sign off for now. I will be off tomorrow, but I will be coming back in on Thursday, and we'll be hitting the ground running on Thursday. So have a wonderful night, everyone. Thank you all for joining me. As usual, it's been a pleasure. Go rest with Pearl. I know she's still mad at me about the squirt bottle situation, so we have to talk. But have a wonderful rest of your night. Thank you all for joining me throughout the day. And tonight, I'm always very thankful for your time and effort. Thank you to the moderators, of course. Oh my gosh, my angels, my heroes. Thank you so much for coming and helping me. I'm so grateful for all of you. So have an amazing night, everyone. And I will catch up with you very soon. So I have a purple thumb. I've got to go do my nails again. So take care, everyone, and I will be back very soon. Have a great night.